Good morning, class. Settle down, please, and pay strict attention. Let's jump right in. In today's explainer session, I need you to open your notebooks immediately to question 24. Today, we are dissecting a high-yield 16-mark question that appears repeatedly in your KSLU examinations. Discuss the rights of an unpaid seller against the goods and the buyer. We aren't merely reading the law today, class. We are learning exactly how to present this on your answer scripts to command maximum marks from the evaluator. So set aside any distractions. This requires rigorous academic focus.
Right. Here is our exact roadmap for today's explainer. Number 1, who is an unpaid seller? Section 45. Number 2, Part 1, rights against the goods. Number 3, Part 2, rights against the buyer. Number 4, landmark case laws analysis. And number 5, conclusion and exam strategy. I highly recommend writing this exact synopsis on page 1 of your answer booklet.
Let's start with our very first mandatory heading. Section 1, who is an unpaid seller? Section 45, fundamental definitions under the Sale of Goods Act 1930.
Now, do not start your exam answer by meandering with some generic introduction. You must cite the correct Bear Act section number, Section 45, immediately. Let's read the definition exactly as it appears on screen. Unpaid seller, Section 45. A seller is unpaid when the whole price is not paid or a bill or check received is dishonored. Notice that strict "or" condition here, class. This is absolutely crucial. A seller becomes legally unpaid if either one of these two independent conditions is met. Either the whole price is simply not paid in cash, or a negotiable instrument, like a bill of exchange or a check given by the buyer, bounces. It's dishonored. Listen, even if a buyer pays 99% of the price and holds back just 1%, the seller is still, legally speaking, an unpaid seller under Section 45. Underline that word "or" in your notes right now. Precision is what gets you marks.
Moving on to the first major branch of remedies. Heading number 2, Part 1, rights against the goods. Examining sections 47 through 54. Make sure to underline this heading. We are going to divide the seller's rights into two distinct parts, starting exclusively with the physical goods themselves. Let's look at this table. First row, right of lien, sections 47 to 49. Second row, right of stoppage in transit, sections 50 to 52. Third row, right of resale, section 54. Listen carefully, class. Drawing this specific table in your KSLU exam booklet is a brilliant strategy. It maps out the specific sections in a highly structured format, and it guarantees maximum marks. It tells the examiner instantly that you know exactly where these provisions sit within the Bear Act.
Let's dissect the right of lien, sections 47 to 49. Meaning, retain possession of goods until payment. When available, sale without credit, credit expired, buyer insolvent, termination, delivery to carrier, waiver of lien, buyer obtains possession. You've got to write down every single one of these points. Let me deliberately elaborate on those termination conditions so you don't lose crucial marks. You see, a lien is entirely dependent on possession. The very moment the seller delivers those goods to a carrier for transmission to the buyer, without reserving the right of disposal, that lien is destroyed. If the seller explicitly waives his right, the lien is gone. If the buyer lawfully obtains possession, the lien is terminated. No possession, no lien. It really is that simple, so make that extremely clear in your answer.
Next up, the right of stoppage in transit, covering sections 50 to 52. Read the screen and notice the strict chronological progression required here. Step 1, buyer becomes insolvent. Step 2, goods are currently in transit. Step 3, seller stops goods and regains possession. Class, I literally cannot emphasize this enough. Sections 50 to 52 only trigger under these strict chronological conditions. The buyer must be legally insolvent, and the goods must have left the seller's physical possession but not yet reached the buyer. They're stuck with a middleman, a carrier. Think of it as an extension of the right of lien, designed specifically to intercept the goods before a bankrupt buyer gets their hands on them. Write these 3 steps sequentially.
Now moving to the ultimate right against the goods, right of resale, section 54. When allowed, perishable goods. When allowed, notice given to buyer and buyer defaults. Effect, seller can recover loss. Effect, buyer loses rights. Let me sternly warn you all right now, do not forget the mandatory notice given requirement in your exam. It's a game changer. Unless the goods are by their very nature perishable, the unpaid seller absolutely must give notice to the buyer of his intention to resell. If he gives notice and the buyer still defaults, the seller resells and can recover damages for any loss. But if he fails to give notice, he cannot recover damages. Do you understand the severity of this provision? Highlight the word notice in your study materials right now.
Let's move on. Section 3, Part 2, Rights against the buyer. Personal remedies under sections 55, 56, and 61. Start a fresh paragraph for this one, class.
We have now fully left the realm of physical goods. Let's compare the two. On the left, Part 1, Rights against goods. Secures the physical goods when the buyer defaults, sections 47 to 54. On the right, Part 2, Rights against buyer personally. Allows direct legal action against the buyer for financial recovery. I want you to read this carefully and really absorb it. By explaining this legal duality in your answer, you're going to write a vastly superior analytical paragraph. You are showing the KSLU examiner that you understand the true architecture of the Sale of Goods Act, that it provides a two-pronged shield for the seller. One shield guards the physical goods, while the other acts as a sword against the buyer's finances as an individual entity. Let's methodically break down these Part 2 remedies. Suit for price, Section 55, when property has passed but price unpaid. Suit for damages, Section 56, for non-acceptance of goods. Suit for interest, 61, seller can claim interest on unpaid amount. I urge every single one of you to memorize sections 55, 56, and 61 sequentially. It flows logically. If the ownership, the property, has passed to the buyer and they simply refuse to pay, you use section 55 to sue for the exact price. If they wrongfully neglect or refuse to accept and pay for the goods, well, you sue for damages under section 56. And finally, under section 61, the court may award interest on the outstanding money. Write them exactly in this order.
All right, Section 4, Landmark Case Laws Analysis. Mandatory citations for maximum KSLU marks. Let me speak with absolute authority on this matter, class. A 16-mark answer in a law exam without case laws is an incomplete answer, period. It will cap your score no matter how beautifully you described the sections earlier. Case laws are the absolute backbone of your legal argument. First up is Lickborough v. Mason, which established principles of stoppage in transit. I want you to aggressively instruct yourselves to write this case name in a boxed format to command the examiner's attention. The background of this landmark case involves the very essence of stoppage, where goods were actually on a ship moving toward a buyer who unfortunately fell into insolvency before taking physical delivery. The ratio descendendi, the final verdict of the court, cemented the rule that a seller's right to stop the goods during transmission is paramount to protect them from the buyer's bankruptcy. The absolute relevance of this case is that it birthed the very statutory provisions we just read in sections 50 to 52. So box the case name, underline it, make it stand out.
Our next landmark case is MS Shalimar Chemical Works Limited v. Surinder Oil and Doll Mills. As the text says, this clarified rights of the unpaid seller, including lien and resale. The facts here revolved around a complex commercial transaction where the seller had forcefully exercised their rights over goods when payment failed. The court's verdict explicitly validated exactly how and when a seller can legitimately hold on to goods under a lien and subsequently resell them to mitigate their financial damages. The relevance of citing Shalimar Chemical Works on your exam paper is absolute. It proves to the evaluator that you know how these ancient principles of lien and resale are being actively applied in modern corporate Indian courtrooms today. Put it in a box. Ensure the examiner cannot possibly miss it.
Finally, Section 5, Conclusion and Exam Strategy. Securing commercial fairness and final marks. Now, whatever you do, do not abruptly end your essay right after the case laws. Prepare your concluding remarks to secure those final 2 marks of the question that most students carelessly leave on the table. Let's review this checklist. Protects seller from financial loss. Balances rights of buyer and seller. Ensures commercial fairness. Protective mechanism through rights against goods and personal remedies. I am explicitly guiding you to use these exact phrases in your final paragraph. Please do not invent your own casual vocabulary here. By stating that the law ensures commercial fairness and acts as a protective mechanism, you show the evaluator a firm, commanding grasp of commercial jurisprudence. It shows real maturity in your legal writing.
So before you hand over your paper, ask yourselves this vital question. Does your final answer clearly demonstrate how both rights against goods and personal remedies form a complete protective mechanism? Treat this as your ultimate checklist. Because if you have mapped out Section 45, drawn the table for Sections 47 to 54, explained the personal remedies under 55, 56, and 61, boxed your case laws prominently, and concluded with commercial fairness, you are going to secure an exceptional grade. Class is dismissed. Study hard, write strictly, and claim your marks.